Assaulting a law enforcement officer, other than a police officer, is an offense under Section 60A of the Crimes Act 1900, which carries a maximum penalty of 5 years in prison. To establish the offense, the prosecution must prove beyond reasonable doubt that you assaulted, threw a missile at, stalked, harassed or intimidated a law enforcement officer other than a police officer. An assault is where 1. You caused the officer to apprehend immediate and unlawful violence, or you made unauthorized physical contact with the officer. 2. The officer did not consent, and 3. Your actions were intentional or reckless. A law enforcement officer includes 1. An ICAC commissioner, assistant commissioner or officer. 2. An officer of the Law Enforcement Conduct Commission. 3. A NSW Crime Commission commissioner, assistant commissioner or staff member. 4. A corrective services commissioner or governor or correctional or corrective services officer. 5. A juvenile justice officer. 6. A crown prosecutor, acting crown prosecutor or DPP lawyer. 7. A sheriff. 8. Special constable or other person recognized as a law enforcement officer under the Police Act. And 9. An officer of a charity who performs animal cruelty investigations. An action is against a law enforcement officer even if the officer is not on duty, if it is carried out due to 1. Actions by the officer while executing his or her duty, or 2. The fact the officer is a law enforcement officer. The maximum penalty increases to 7 years in prison where you inflicted actual bodily harm on the officer, which is harm that is more than transient or trifling, and includes lasting cuts, bruises, and abrasions. The maximum increases to 12 years in prison where you inflicted grievous bodily harm, GBH, or wounded the officer. GBH is defined as really serious harm. It includes, but is not limited to, 1. Any permanent or serious disfiguring. 2. The destruction of a fetus, other than by a medical procedure. And 3. Any grievous bodily disease. A wound is the breaking of both layers of the skin, being the dermis and epidermis, and includes a split lip. Duress, necessity, and self-defense are legal defenses to the charge. In the event you are able to raise evidence of a legal defense, the onus then shifts to the prosecution to prove beyond a reasonable doubt that the defense does not apply in the circumstances of the case. You are entitled to an acquittal if the prosecution is unable to do this.
Going to court. Call Sydney Criminal Lawyers on 9261 8881 to arrange a free first conference. Watch our latest video here.